Yes.
And my ladies, I addressed you very briefly on ground 4 and grounds 5 for lunch, just to say in respect of ground 4, I don't propose to add anything to my skeleton argument to paras 54, 55. In respect of ground 5, I've made my primary submission, which is that if Ofsted is right about the application of the Equality Act, the Article 9 balance has been struck within the Equality Act in any event. The skeleton argument then sets out at paragraph 59 and on the analysis on the application of Article 9.
Right, can we just remind ourselves of that and what the judge said about this? 291 to 303.
Yes, that's right.
You highlight.
The judge held at 291 and on that Article 9 wasn't interfered with, in effect, because it drew the distinction between freedom to hold a belief and freedom to manifest that belief. And the reasons that he gave, applying the test of something being a manifestation being intimately linked to religion or belief, derived from Williamson and Wader, he held that the approval of a foster carer was insufficiently intimately linked to the religion or belief to engage Article 9. And that's summarised at my skeleton at 59. And just for the course note, Williamson is at authorities 27 and Wader at authorities 38. At 304 of his judgment, the judge went on to consider whether he was wrong about the interference with Article 9, whether or not that interference was proportionate. And he held that the requirement in question was done in pursuance of legitimate aim, namely protection of rights and freedoms of gay men and lesbians. That's 304. And then he went on in paragraphs that followed to find that that was proportionate, relying in particular on the decision of the Court of Appeal in Liddell. It's at the top of page 74, halfway through paragraph 305. Liddell is of authorities 20, for your note.
Right, can we just link that back to the Delhi 305? What's the reference that he is speaking back to there? Cited in paragraph 295, is it?
Sorry, I'm so sorry. In 305, he goes on to consider Liddell.
Yes. And he refers back to what Lord Newberger said in the
yes, in
Liddell.
So, Liddell, if you'd like to take to that, it's at authorities tab 20.
Yes, sorry, if it saves time, I think that it's set out in 295, isn't it? It was because he said supra, and yes, I'm just going back to see what particular point he was drawing from it. So perhaps we could just look at that quite long quote. Right, this is the Registrar of Marriages.
That's right, yes. It was the evangelical Christian registrar employed by Islington who did not wish to officiate at same-sex civil partnerships. and in that extract, the Court of Appeal effectively weighs the legitimate aim pursued by Islington.
Right, now can we just pull out, because I'm reading across several screens while I'm trying to look at this quote. What is the bit in this that the judge is relying on?
The judge is relying on at well, it's the point that religious views can't be allowed to override Ofsted's desire. So, sorry, let me just see if I can find a precise point. I'm so sorry.
It's paragraph 55, is it, internally of...
Yes, exactly. It's a truncated version of, or truncated extract from that paragraph.
And the quotation at the end of 54.
Yes, that's right. Yes, which is both a point of whether or not Article 9 is interfered with, but also is a matter that may come into the proportionality analysis. And certainly in Williamson, House of Lords said if you scrape over the line into interference, in other words, if you're just into interference, or if the interference is modest, that's a matter that can be taken into account in the justification balance.
Well, the judge thought it was worthwhile to go on and deal with it on an alternate basis in this case. I just want to make sure we don't skate over what's involved here. So,
no.
Liddell, paragraph 55, cited at 295.
Yes, my lord, you have Liddell in its full form at authorities.
Do you need any more from it?
That's the reference that I had.
Right. And you told us that it's at, sorry, tab in the authorities.
Tab 20.
20. Good. If we need to go there at a later tape.
Yes, and you can see that in a very similar vein, paragraph 62, there are a number of other similar decisions, Farlin, Johns, and also Oweda, in which the question of how one balances legitimate aim of sexual orientation against religious aims and the approach taken in Liddell is broadly mirrored in those other authorities cited.
Right, so the judge's resolution of this is perhaps at 297 onwards. I paraphrase that the fact that the running of an agency may be an expression of the Christian mission is not sufficiently closely connected to the beliefs themselves. It's a choice relating to how a person of a certain faith acts,
Yes.
not something that is either doesn't have to be the fulfillment of a duty, but it's insufficiently close to the belief itself.
Exactly. And if that's wrong, then in any event, any interference was not justified. Sorry, was justified by the declaration of
Right. Well,
non-discrimination.
can you just answer Mr. O'Neill's point that the judge then strays into telling Cornerstone how it can fulfil its mission?
Well, Article 9, as is set out in Williamson and other authorities that are referred to, draws a clear distinction between freedom of belief on the one hand and manifestation of that belief on the other. Where a religious organisation wishes to manifest its belief, and where it does so in the public domain, and here acting as a public authority, then there may be restrictions placed upon it as to the manner in which it exercises its religion belief. And that's so taking those in steps, either it's too far away from the core religious function of the organisation, so Article 9 is not engaged at all, or even insofar as it is, then that interference is justified. And it's broadly that if a religious organisation enters into the public domain and exercises public functions, then it's legitimate for the state to place limitations on how it carries out those functions.
The distinction between the belief and the manifestation of the belief I understand, and I take you to be saying that the judge wasn't telling Cornerstone what its beliefs were, but making an objective judgment about how those beliefs could be manifested. That's controversial as between the parties here, because it said against you that Cornerstone cannot manifest its beliefs in the way that Ofsted says it can. So who's the judge of that?
Well, that point is picked up in paragraph 60 of my skeleton.
60?
60 of my skeleton argument, which makes the point that the test of whether it is a sufficiently close nexus between the act in question and religious belief is a matter for the court. I give you the references there to Williamson and Ueda. And I make the point immediately afterwards that if the test was a purely subjective one, then in principle any manifestation of religious belief would be protected by Article 9. That simply doesn't reflect the Article 9 case law. And there are further authorities that are set out in that paragraph making good that submission.
And the question of nexus is a question of fact.
Indeed. Yes, I'm so sorry. I missed those three rather crucial words off from the summary of my submission that I've just made. Precisely so, which is set out in line 3 of the paragraph 60.
Is it significant, as is suggested, that in paragraph 300 the judge says that Cornerstone could continue to have a religious ethos, whilst not placing a blanket exclusion on those of different or no religion?
Well, it comes back to the point that, as matters stand, if Ofsted is right, Cornerstone is discriminating against gay people and steps have to be taken to address that. How that is done is ultimately a matter for Cornerstone. All that Ofsted has required Cornerstone to do is to end the prohibition on those of a particular sexual orientation. Now, what then Cornerstone chooses to do thereafter is really a matter for Cornerstone, whether it that.
Well, I think Cornerstone is saying that that's a Hobson's choice, that it's not really a choice at all, because it cannot have its religious ethos, and that it is the arbiter of what its beliefs in fact are, whether they're lawful or unlawful.
Well, that's difficult in a number of ways. It's difficult first because, of course, there wasn't any evidence for the judge and found as a fact that Cornerstone would cease its operations as an independent fostering agency. So there isn't the evidence before you that Ofsted's conclusion necessarily and inevitably drives the closure of this service. As I say, how that works in practice is ultimately a matter for Cornerstone. That's not a matter for Ofsted. But the second point, as I've indicated, is that Cornerstone is entering into public sphere in the sense that it's undertaking activities on behalf of a public authority, and as I've indicated, with that may come certain restrictions.
Right, so if it does have the apocalyptic consequences that Cornerstone complains about, then so be it.
Well, my Lord, I can only defend the case, the regulatory decision that Ofsted has made. The consequences of that regulatory decision, what Cornerstone chooses to do about it, is a matter for Cornerstone. It can comply by changing its recruitment policy so that it allows persons of all sexual orientation to participate, or it can choose not to comply, in which case Ofsted will consider its position in terms of next stages of regulatory action. But it was open to Cornerstone, with respect, my lord, to put evidence before the judge below as to the consequences, it said, of this decision. If it was saying to the judge below, this would necessarily inevitably lead to its closure, it could have led evidence to that effect. It hasn't, and in my submission, my lord, it would be wrong for this court to assume that that consequence would follow in the face of the unappealed judge finding of the judge below.
Right, that's how it works.
Yes, my lord, it is.
Yeah.
My lord, my ladies, I don't have anything further on the grounds of appeal. My lord friend, Mr O'Neill, put in a note this morning to you about the Charity Commission. I've had a very brief opportunity to consider it. I very much doubt that I will have anything to say in response, but I wonder if I may have a day or so just to consider the position and put in anything further in reply, if necessary. I very much doubt that I will need to.
Well, I understand that. We've had a chance to look at it. It seems to be, if I may respectfully say so, a helpful document of a vanilla flavour.
That's certainly my initial impression, and I would just, if I may, just take the opportunity to take instructions on it and put anything further in.
Well, unless Mr O'Neill has any difficulty, I'm sure that
none whatsoever.
A short rider if you need one, but if not, it's there.
I think if I could just even take until tomorrow, the close play tomorrow, that would be sufficient. I say I very, very much doubt that I will want to reply.
All right. Well, we will take silence as contempt.
I'm very grateful.
No, thank you very much indeed, Miss Hannah. Yes, Mr O'Neill.
My lord, my ladies, I have a few points in reply, necessarily since it's.
Well, since we arrived at this happy point, could you just give an estimate for how long you're thinking you may be on?
I'm thinking a maximum half an hour, but I'm hoping less than that.
Perfectly suitable. Thank you very much.
No, my lords, my ladies, I mentioned this morning the issue of we overnight produced a witness statement. That was simply to assist the court, but it was to respond to two issues which were raised as matters of fact by my Lord Justice Jackson and my Lady Justice Davies. First of all, in relation to the question of the communal event issue as to whether or not the support was just done individually from people across the country. And I've taken instructions on that, and I can tell you what our position is.
Well, have you shared this with?
I have, but to be fair to Miss Hannett, I since it was only finalised just before she got it just before lunch, as did I. In fact,
all right. Well, listen. For the moment, without telling us what's in it, would you just like to tell us who is the statement by?
Yes. The statement is a witness statement from Pamela Birtle, who has...
Right, so that would be her fourth. Because she's made 3 statements already.
Yes, it would be her fourth statement, yes.
Right. And how long is it?
It's 1 page, or 1.5 pages, and it's got... it's 3 paragraphs. Sorry, substantively, it's one substantive paragraph.
Right. And you say that it covers matter that arose in the form of the intervention that I made in relation, or the point that you drew out from the Ofsted report about holidays.
Yes.
That sort of thing. And the second point was?
And the second point was in relation to the, as was raised by Lady Justice Davies, about the other points in the 2019 report. This wasn't simply about the Equality Act issue. There were other issues, and all that I'm told is that there has been a subsequent report which expresses, from Ofsted, which expresses satisfaction with the manner in which those other matters have been dealt with, and it was to reassure the court that those matters were being.
Well, now, Ms. Hannett, things being as they are, you won't have had an opportunity to consider or take instructions on this, or have you done so?
I can reply on both points.
Well, I'd like to maintain a semblance of principle about this. Mr O'Neill is about to make an application. He's just told us what the application is about. Of course, if the application is not opposed, then we don't particularly need to trouble ourselves. But
as I say, I haven't taken instructions, but I'm almost certain the application will be opposed.
You?
I have not taken instructions yet, but the application, I'm certain, will be opposed.
It will be opposed. Do you need any further time to consider it before we hear
Can
from
I
Mr.
just
Knowles.
at least turn my head for a moment? I don't think I need more than a moment or two to do so. But
All right. Well, we'll just sit quietly for the moment while you take any instructions.
Excuse me, I'm going to turn my back on you for a moment.
Are you in a position?
I am, my lord, yes.
All right. Well, let's start with Mr. O'Neill then, and I just didn't want to draw you into arguing why this should be put in at this stage, although you may have got halfway there.
Indeed. So on the basis that it is opposed, I will set out why it is it's coming in.
Right. Do you have copies of it?
I have, yes,
All right.
and I've
Well,
given a copy too.
thank you very much. Let us, if there's somebody, thank you very much. Right.
Okay.
We're going to look at it just so we know what we're talking about.
Of course.
Thank you. Didn't see you down.
Thank you.
So it's a short statement, but it attaches a public document. Is that right? Is this in the form of a public document, or is it simply something as between Ofsted and the organisation?
Again, I'd have to double check on that. I think it's a public document on the basis.
Are they published, these assurance visits? All right, so there's an assurance visit. There is
Something else.
and an email.
Yes, the emails are in fact
Two emails.
two emails which are from families.
All right, so they all fall into different categories.
They do, yes.
Right, well, we'll read the statement itself. Yes, we've all had a chance to read those. Thank you.
Yes, and so as I say, the points which they speak, I don't know if you want to hear further from me on this.
Yes, please. It's your chance to
Yes,
make the application.
oblige. The points which they speak to are responding to, as I say, your Lordship's statement, questioning as to how the support which was spoken to, the specialist faith-based support actually
Yes.
worked in practice, and really, it's,
Well, I'm bound to say
given-
what I'm reading.
Yeah.
I don't know whether it seemed to Miss Birtles that I was talking about something different, but I'm bound to say what I'm reading is very much what I'd imagined
Yes.
the case would have
But
been.
and it's simply it's what I had thought too, but it's simply reflecting that, and so in that sense, it is responding to when the court asked for further clarification as to what the matter was. We've produced a further clarification simply in the form of a witness statement.
Are we touching on holidays in any of this?
I think this has been this speaks to the period of lockdown, so there haven't been holidays.
Of course.
And so that's why it hasn't gone into that. It's just been what's been happening since. And the other point was because there did seem to be some concern from the court about that there were a whole series of other matters in the 2019 report which had to be dealt with, and it wasn't simply the equality and human rights issue.
I don't think, although I may not have raised the point myself, that we will have felt any particular concerns about that. It was simply a question of the description of what the report consisted of, which was some good, some less than good points. But you say that on the public record has moved on, as one would expect.
And indeed, but what does remain, and it's the reason why we're both in court, I think, as we both accept, is the requirement to change the religious belief.
Which is
And
referred
that's
to
what we see
specifically in...
Yeah, and it's specifically maintained.
All right.
So it's simply an up-to-date accurate position.
Now, are you opposing this being admitted, and what's...
Well,
What's
I am,
the position?
because it is evidence that wasn't adduced below about the manner in which Cornerstone runs its activities. There's no explanation as to why this evidence, which could have been adduced below, particularly from the individual foster carers in question, wasn't. To say that the evidence has been produced rather at the 11th hour is the end of my submissions in reply on an appeal. It wasn't before the judge below. It doesn't meet any of the criteria as far as I can see in terms of admitting evidence on an appeal. And in that respect, I say it shouldn't be admitted. In respect of the assurance visit, my objection is really on relevance grounds, in the sense that Ofsted accepts that if it's erred in law in respect to the Equality Act findings in the report, the whole report must be quashed. It's not bits of it aren't salvageable. And so the status of the remaining recommendations is of my submission no real relevance to the court's determination. So, Lord Melodies, those are my submissions on the evidence.
I entirely understand the points you make as to the fact that certainly part of this could have been adduced at the trial before the judge. That being said, do you say this takes it any further?
No.
No.
No, I don't. But I do say it's a particular note that emails are now being adduced from foster carers, despite the fact that the submission being made below before the judge, that the evidence was thin on the activities, how they were carried out, and what difference religion made. So I do maintain that submission. I don't say that it makes any difference to the analysis that I have set out this morning, but I still maintain the submission that it doesn't meet criteria for late evidence.
Good. Thank you very much. All right, well, we'll rise just for a moment in order to consider this point. Well, Mr O'Neill, we're not going to admit this further statement. We will take note of the report of the assurance visit, which it contains, a public document. But in other respects, these are matters that could have been placed before the court at an earlier stage. Thank you. Yes.
Right. Yes. If right. I have a number of discrete points, which are necessarily because, in a sense, one's responding to what's been said.
Yes.
And so I apologise if there isn't a structure, and I appear to be attempting to jump around a bit. But as I say, I'll try and make the discrete points. Before I start, though, I would like once again to apologise and explain to Lady Justice Asplin that the references I was making yesterday to Erastianism was a reference to what happened in the 16th century in terms of the Tudor whatever. And when I realised I used the word Tories, but I was referring to the 17th century concept of Tories as royalists, and it was the alliance between those who had formerly been opponents in the Civil War, which then set up the constitutional basis of toleration and religious freedom. But in no sense was I wishing to dismiss or dissent from the Anglican Church, the Church of England as it.
I was just concerned about the possibility that at the end of the day we were tarring various groups with various brushes, and I didn't think that was appropriate.
Well, certainly not. The chairman of Cornerstone is an Anglican priest.
I once wrote an opinion when I was at the bar, which began something like, as instructing solicitors will be aware since the Reformation. So I shouldn't get at you for going back to the 1680s.
But in no suggestion I was certainly not suggesting that the Church of England was the Conservative Party of prayer. I mean, so I'm sorry if I used loose historical terminology, perhaps, which is different things nowadays. My learned friend said that the evidence about the religious motivation and the like was thin in the court below, but that is because, and this is what has marked the submissions throughout from Ofsted, they accepted that the religious belief requirements were lawfully put in place and maintained in accordance with the requirements of paragraph 2 of Schedule 23. It was never an issue that we had and we were a religious organisation which was lawfully making religious belief requirements of foster carers and employees. So it's slightly odd to come out now of the month of Ofsted saying what you didn't bring in evidence about that, because it wasn't a matter which was in fact in dispute. And none of the submissions which we've heard, either in the written argument or in oral submissions from Ofsted, has faced up to the fundamental point in this case, which makes it unlike any other case, which is that the judge below found that the religious requirements as imposed by Cornerstone were lawful and justified. Not simply in terms of the Equality Act, as Ofsted had somewhat reluctantly conceded, but also, as Ofsted disputed, in terms of the Human Rights Act. So, as I say, unlike any other court, we are then have the situation that those religious belief standards as imposed by Cornerstone have been found to be justified and lawful by a court, and that Ofsted do not challenge that before this court. Now this is, as I say, the central issue at some levels in this case, because what is allowed for in paragraph 2 of Schedule 23 of the Equality Act are the possibility of the organisation itself imposing or the organisation itself imposing restrictions relating to religion or belief, and they will be justified if it's because of the purpose of the organisation or because to avoid causing offence to fellow co-religionists. It is not, and it is not permitted under the Act for it to be, the court has allowed the justification of religious belief requirements such as it considers to be acceptable or as might be modified. That is not what Section 20, Paragraph 2 of Schedule 23 allows for. It is the restrictions which that organisation has imposed having regard to its purposes, its religious doctrine, and its particular situation.
It's your point, Mr O'Neill, that they have no power to rewrite.
Yes.
That's your point.
That's my point. That's my point, and that would be an interesting point in itself. But given that it has no power to rewrite, we then have a finding by the court that it was justified. And it was those requirements which were justified in their fullness, which referred to, among other things, homosexual behaviour, but all sorts of other sexual and non-sexual matters which were nothing to do with sexual orientation in any way at all. Now, if Ofsted had wanted to be coherent and say, actually, however, as they are now saying, is that those very religious belief requirements which we accept, which the court below positively ruled against us, were justified in terms of the ECH, of the Employment Equality Act and under the Human Rights Act, they should have appealed that point. But they didn't. So those restrictions, although the judge in his judgment goes on and perhaps says, well, there could be other kind of restrictions which an organisation could maintain a religious ethos compatibly with views about sexual orientation. It was not those restrictions which were approved of and held to be justified by the judge. So that's the paradox of this case, which, as I say, makes it wholly unlike any other case which has come before the court. And the reason it is the way it is because Ofsted did not appeal that central point. And instead, by a attempted sidewind, they say, nonetheless, however, because of these concerns expressed on sexual orientation, what one has to do is to read the judgment below as having approved, for the purposes of the Human Rights Act and for the purposes of paragraph 2 of Schedule 23, religious belief requirements that were other than those imposed, in fact, by Cornerstone. And that's just not possible. So, all this reference to, and it's interesting how what was the focus on what is direct sex discrimination, what is indirect sex, or sexual orientation discrimination. It all makes sense if you had a blank sheet of paper, a carte blanche. Here is a requirement. Can it be shown to be justified? But this is a requirement which has been accepted to have been justified as a religious belief requirement. And so, as I say, it is not possible, as effectively that seems to be the substance of this case, that this court should in fact read the judgment or itself rule that there is a justification, or the religious belief requirements are justified if and only insofar as they are modified to take away, as I said before, the reference to having to live in accordance with traditional biblical morality, or to accepting that sexual activity is only within the context of a Christian marriage. So that's why, in a sense, this our submissions are missing each other because Ofsted haven't faced up to that central point in this case, as I say, which makes it unlike any other. It makes it unlike, in particular, the GFS case, which my learned friend referred to, because in GFS there was no prior finding by any court below that the religious belief or the religious requirement of matrilineal succession, matrilineal descent in order to be admitted to the school was justified. My learned friend skated over that and said, well, it was known, it was applied. But the very question as to whether or not it was justified was the very question before the court. And it ruled that, having looked at it, this religiously based requirement did not face complete scrutiny under and in terms of race discrimination. GFS is a difficult case. It's a 9-judge case with a very, very divided court on a complicated particular factual background against a background where Judaism is accepted both as being a religion and as an ethnic group, as was established under the Race Relations Act. So one can see why issues of race coincide in the specifics of the particularity of Judaism crossing those divides, why that is an issue where you could see that religion and race issues come up. But as I say, the fundamental difference in it, however, is that there was never any finding that that religious belief requirement was a justified one. As I say, Ofsted was on a cleft stick. If they had wanted to argue that the religious belief requirement was in fact, in its terms, justified in terms of sexual orientation, they should have appealed the judge's finding that it was. So that's I think that's one issue. Yes, can I now turn to the discrete issue of sexual orientation as distinct from sexual behaviour? I suppose the first point which I make is that the protected characteristic under the Equality Act is sexual orientation, not sexual activity. But my learned friend, in her glossing of sexual orientation, means it must be something to do with sex. But again, that's not right. It is possible to define oneself as heterosexual, as gay or lesbian, while having being a lifelong virgin, or having committed in later life to celibacy. There is no requirement of sexual activity in any sense at all as being definitive of what one's orientation is.
How do you deal with amicus?
Well, precisely in amicus was the case I was in, arguing for the claimant union. All that was said in amicus was that in order to protect the concerns of religious organisations, to say we are not discriminating on grounds of your orientation, but on grounds of your behaviour, then the particular wording at issue in that case was there to allow precisely the religious organisations to make that distinction. It was, as it were, a shield for the religious organisations to say we are not referring to orientation but behaviour, and it is not a sword with which to expand a definition within the Equality Act 2010 now, where different wording is used, and it's interesting when one looks at how the wording has shifted in response to the case law in terms of Equality Act. The wording is because of, if it's direct discrimination, because of sexual orientation. And as I say, it is a plain reading of that because of sexual orientation has to be, it doesn't mean it is necessarily anything to do with any kind of sexual activity whatsoever. And I don't think that is in fact suggested in the amicus case at all. And it is that distinction between behaviour and orientation which is important and which is constantly being elided in this case by Ofsted. At one point, my learned friend says, well, look, you have specifically excluded homosexual behaviour or specified homosexual behaviour. That's indissociably linked with orientation, and therefore you've got direct discrimination. But you have a whole series of instances of sexual immorality which are listed, which are clearly nothing to do with a particular sexual orientation, homosexual orientation, adultery, cohabitation, fornication, looking at pornography, immodesty. They're not related to any particular orientation. But also, perhaps more importantly, that those sexual sins can be committed to those who are within a Christian marriage. It is obligation. So getting into the Christian marriage does not then absolve you of the responsibility. In fact, if anything, it probably makes them stronger, because you then have actual duties of fidelity towards the other partner, your spouse, in that marriage. So it is unlike, for example, the case of Preddy against Bull, where all that one, well, first of all, that said heterosexual married couples, so it was specifically about orientation, in which we've not. But also, if you were a heterosexual married couple, it wasn't any reference to it being a Christian marriage. If you were a heterosexual married couple, then you got the benefit of the double bed, which those who are not a heterosexual married couple did not. Whereas in this case, you can be a fully Christian, in a complete Christian marriage, but that doesn't then give you, you don't then get all the benefits of it's a sexual free-for-all now. One is what those, there is no disapplication of the requirements of maintaining standards of sexual fidelity and chastity in accordance with traditional biblical morality for those who enter into a Christian marriage. And the other point to make, of course, is that what constitutes a Christian marriage is not mapping directly onto heterosexual marriage. You can have heterosexual marriages which would not be regarded as Christian marriages. And we're not going to go back to Reformation on this one, but it is well known that the Church of England in particular has issues in terms of the possibility of remarriage in church, sacramental marriages might be said in Catholic terms, for those who have still living spouses who are divorced and their spouses are still living. So that is an issue. There used to be an issue about whether it was a Christian marriage to enter into a marriage with one's deceased wife's sister, and there was all sorts of litigation about that in the early 1900s, and until specific statutory provision had to be made on the Deceased Wife's Sister's Marriage Act in about 1910. So was it? It might have been later than 1910, but there are those cases to do with Law Justice Laws has an article all about this. To do with people.
Is this really taking us much further on this point?
Yeah, but the point is, and it's just an historic example of the fact that being in a heterosexual marriage does not mean to say necessarily you're in a Christian marriage. So though it is an important point, my lady, although it might seem abstruse in terms of the historical examples, but it is important because the central issue which has been said in terms of direct sex discrimination is that there is an indissociable link between the requirements in this case and orientation. And my point is that that is not the case.
Right.
And that is why I refer to specific examples which show that it is not the case. And I do think it is nice sometimes to actually stick to factual examples rather than, as has happened in this case, and that's one of the main problems, in that in pursuit of the virtue of regulatory compliance, as I think my learned friend called it, we then have a decision which is unanchored in any actual facts. My learned friend says it doesn't matter, actually, that there are no identified victims. It's still a breach. But again, what she has not dealt with is that on our evidence, it is not possible for there to be the identified victims which the judge below, from his judicial knowledge.
The point that you make, and I sought to take up with Ms. Hannett, is it's not that they're unidentified, it's that they're non-existent.
Non-existent, absolutely. So if you have non-existent victims, then the idea that somehow notionally out there, not in reality, not in the world of phenomena, but in the world of the noumenon, there is a breach of the law, although no one can actually be a victim of that breach, it makes nonsense of a finding that there is a breach of the law. So that's the victim requirement, which could be said, well, that's just to do with the Human Rights Act. But the direct...
Well, one can't take it too far, but we're seeking to, as it were, identify the points. That it wouldn't do you much good to put in your front window a sign saying no blacks, if in fact you didn't have any bedrooms to let. So there might be no victim, because nobody was going to get a bed anyhow. But there is a public element to this as well, as I think we'd all accept. But we've understood your submission in regard to non-existent versus unidentified, and we've understood Ms. Hannett's submission about the, as it were, overarching responsibilities of Ofsted that don't peg necessarily onto single victims.
But interestingly, picking up on your Lordship's example, that if it were effectively, although we're not a boarding house, if we were, we wouldn't rent it out to black people or Jews or Irish or whatever. Yeah. That would not be a discrimination claim. That might be a public order claim. It might have issues about inciting racial hatred and the like, but it wouldn't be a breach of the Equality Act because you've got nothing to discriminate about. It's an expression of opinion, really. And so, and it wouldn't be a breach of the Human Rights Act. There are all sorts of other things it might be of, but the problem is that this Ofsted are relying on these acts and saying that these acts can apply in the circumstances where there are no victims. But the other point to make, which again is important, when it comes to direct sex discrimination, one has to make a comparison with the comparator. Page 67, tab 4, section 23 is set out there. And that says comparison by reference to circumstances. So on a comparison of cases for the purposes of direct discrimination, there must be no material difference between the circumstances relating to each case. Now that's got to be meaning that one has to have a case that one can make, which is why the judge below talked of, well, the comparator is the gay evangelical Christian. But if that is not an actual comparator that can exist, then there isn't a comparator for the purposes of it being direct sex discrimination. And that cannot be got round. When it came to the indirect discrimination point, again, there was some questioning of how one carries out the balance. But as I've said already, as I said in reply to Lady Justice Davies, the problem with the proportionality exercise, or the various ones carried out in the court below, is that it didn't follow through on the court's earlier own finding, which is accepted and not challenged by Ofsted in this case, that this was a case in which the religious requirements, as specified by Cornerstone, were justified. It is again, that is something which had to come in. That's what you started off from. I found these to be justified. How can they then be unjustified? In a sense, is a major starting point. So the judge has got it wrong from the start. So this isn't a question of paying deference to the court below when it's misdirected itself on the very starting point of where it should be coming from. But in further submissions on the indirect discrimination balance point, my learned friend came to the position that the positive effects of the religious faith that is spoken to by the carers, and which was mentioned and the judge was asked to take into account, were, said Ms Hannett, to be discounted, taken out of the balance altogether. And why is that? Because, in a sense, as I understand it, it's because the positive aspects of getting sustenance, of feeling resilience, of feeling supported, and all the rest of it are tainted because the religious beliefs upon which they are based are discriminatory. And therefore, they have to be struck out and removed. Now, that's an extraordinary submission. It's an extraordinary claim to make, because in effect, it says that just about, if you adhere to a religion which does not accept the complete equality of gay and straight, then any action motivated by that religion which does not accept that complete equality is to be of no account when it comes to questions of the proportionality of the actions which are motivated by that. No matter how good the actions are, it goes back to the root of the fact that you're following a discriminatory religion. But how many traditional religions accept the complete equality of gay and straight? Certainly I can't think of any mainstream Christian organisation that does. Certainly the Catholic Church doesn't. The Anglican Church of England doesn't. Much of the Southern Cross of the Anglican Communion does. I mean, the Episcopal Church in the United States perhaps is the standout on that. But it is very much a standout. But it's not just Christianity. I personally, and this maybe,
well, I think we all have our understandings of world religions and their stances on this sort of thing. I think that the point that you seek to make is that if this applies to Cornerstone, it can't be assumed to apply only to Cornerstone.
Yes, it applies to the vast bulk of religiously based, whether it's Islamic, Judaism, Orthodox Judaism. I mean, liberal Judaism might be different, but Orthodox Judaism.
Well, I think I'm shutting down on.
Yes, I've done my tour d'horizon, as it were. But the court has the point. Sorry, my computer's just shut down as well. But the one thing I would say, though, that issue of if the motivation is on the basis of a religion which does not accept the complete equality of gay and straight, means that you discount their actions. It means you're even going further than Elizabeth Tudor allowed for, in that you are seeking to make windows into people's souls. In the sense that what is it that's motivating you for this apparently good work? And if it's, well, you have a religious belief which doesn't accept the fundamental premises of equality law, then it's to be discounted. That cannot be the proper approach. My learned friend made the point that we have not suggested that any provisions of the Equality Act should be are convention incompatible. It's not much of a point, but the whole point is, of course, that all provisions of the Equality Act, as any other act, have to be interpreted and applied in the particular case in a manner which is convention compatible. Guiding against Good and Mendoza tells us that. So, of course, I say that when you apply it in the particular circumstances of this case, it's not just the plain wording, but it's in a manner which ensures, if at all possible, under the Section 3 interpretative obligation, that ensures respect for convention rights. So I don't have to challenge any provisions, I just have to know that the discipline of this court is that those considerations will be taken into account so far as is possible. The other point which was laboured heavily by Millennium Friend was this constant claim that a religious motivation isn't, I think sometimes Ofsted use the phrase, it's not a solvent for religious belief, it's not a solvent for legal obligation. Religious motivation is not a solvent for, is not an excuse for discriminatory attitudes. But the point is that this is not, as we constantly say, a discrimination because of sexual orientation. It is because of religion or belief and may have consequences for all sorts of persons' sexual activity. But it isn't because of their sexual orientation, it's because of what the requirements of traditional biblical morality for all people, regardless of the orientation, has to be seen to be. There And then if it's, I've got two more points. I'm conscious I'm leaping.
No, thank you, Mr.
There was a discussion about Article 9 and the Liddell case and the reliance upon the court below saying Article 9 is not even engaged in this case and apparently referring to and relying upon the Court of Appeal in Liddell case in 2010. But of course, Liddell was a case which went to the European Court of Human Rights and was reported as a reader, which is in the bundle at tab 38. It was conjoined with a number of other cases, but Ms. Liddell was involved in that. And the important point about this case from a Strasbourg perspective is that it did mark a significant shift in the approach which had been taken heretofore by Strasbourg, which basically said if you've got a problem, religious-related problem in the workplace, in that your employer is not allowing you to do that which you think religiously you ought to do, then the solution to it is you resign and find another job. Now, in Liddell, and Erida and Liddell, they changed that position and said, no, in fact, that is not the position. You'd still have to carry out. There is a possibility that employers have to make reasonable accommodation for the religiously based requirements in the workplace. And they can only not do so if not to do so would be justified. And specifically in relation to the case of Liddell, she was the third applicant in the case, and at page 1157 in the electronic bundle, or 217 of the report, we see that her position was summarised at paragraph E at the top. The third applicant's objection to participating in same-sex civil partnerships was motivated by her religious beliefs and fell within Articles 9 and 14. Now that's, whereas the judge below said, no, it doesn't fall within Article 9 at all. So, again, and Lady Justice Davies said, well, and that's a question of fact. But it's not. No judge reasonably directing himself on the basis of the relevant law, which was Liddell, Erida Liddell, as well as Preddy and Bull, could have come to that decision that there was no nexus such as to engage Article 9. That is unsupportable. Liddell is a situation in which the court confirmed there was engagement of Article 9 and then went on to consider the justification exercise as to whether or not, for the purposes of Article 9.2, there being engagement of her religious free expression rights, there had been justification shown to be the case. And the justification in that case was found at paragraph 106, saying it's whatever the National Court did was within the margin of appreciation to be afforded to the state. Now there's a fairly forthright dissent in the decision in Avida about that, as it were, hands-off position. But the point is that it is in an example of the Strasbourg Court holding that Article 9 is engaged and that therefore you have to engage in the issue of justification for that religious belief. And as I said, what's happened in this case is that the judge has taken it upon himself then to say what a properly justified religious belief in his view would be, and improperly approached issues around religious doctrine and who properly are members of a particular religious community.
So I think, just following this through for Liddell as decided in Avida, there was no violation of Article 14 taken with Article 9. I'm just looking for the Article 9 decision in regard to the third applicant.
It's paragraphs 102 to 106, pages 1188 in the electronic bundle, or 248 in the
1188
in the electronic bundle.
Thank you very much.
Paragraphs 102 to 106. I'm sorry, my lord.
No, it's 1188. Sorry, I'm just.
I'm sorry, my lord.
Just following the.
Yes.
I'm trying to understand what they did and didn't accept about Article 9.
Well, at paragraph 103, they accept that for the court it is clear that the applicant's objection to participating in the creation of same-sex was motivated by her religious beliefs. They were within the ambit of Article 9. And then at 106, it does the justification.
Right. It was not just. It was justification for.
It was justification under Article 9.2, but what they say that it was directly motivated by and therefore fell within the ambit of her religious beliefs. And the judge below said that it didn't fall within the ambit at all.
Yes,
and under reference to the necessary nexus wasn't there, and that's not a finding of fact, that's a misdirection in the law. My learned friend took the court briefly to the Catholic care case. I'm not going to go back to it, but I just simply highlight in that as in the paragraph she noted, in paragraph 15, that the court expressly noted that the Catholic Care Agency allowed for foster carers from all sorts of denominations. It just wanted them to be in a heterosexual nuclear family, and it wanted to make that explicit. Called it a Nazarene family, but I think it just meant nuclear. Finally then, I think, unless there are any particular points, is the section 193 issue, which was dealt with really quite briefly by my learned friend. But, and it seemed to be on her reading that it does involve the rewriting of the provision in the way that I had suggested. We were in fact committed to. And it might be useful just to have the wording before one. It's at page 73 of tab 4 of bundle of authorities bundle. it says, a person does not contravene this act. Now, that's what I place major reliance on. But my learned friend says, only by restricting the provision of benefits to persons who share a protected characteristic is what she places reliance on. And I think then implicitly what's being said is that whereas I say that section 193, if you pass it, as we do, according to the Charity Commission, means that you do not contravene the Act and cannot therefore be opened up to claims of discrimination on other grounds in relation to your charitable instruments. Lenfriend says no, all that section 193 does is stop other claims for discrimination on, in this case, religion or belief, while still opening up the possibility of other regulators, other parties, still attacking those very same approved requirements, religious requirements in your charitable instruments. I say that that reading goes directly contrary to those broader policy considerations, the protection of charities, which were spoken to in Lord Sale's judgment, in particular in Z. And so therefore the reading which is being proposed is not one which is there in terms of the plain wording of the Act. It requires a form of eisegesis rather than exegesis by reading of words into the Act which are not there in order to reach the predetermined result.
So if you don't contravene the Act in one respect within the terms of 193, then you can't be found to have contravened it in another respect.
By those religious, by those particular requirements that have been approved as being justified under 192, yes. You cannot then open up that claim by saying, oh yes, but even although these religious belief requirements have been approved and are a proportionate means of achieving a legitimate end, they result in age discrimination, and I'm going to, or they result in sexual orientation, or potentially in this case, because we saw the reference to birth sex, they result in discrimination on grounds of gender assignment. The point about the section 193 is that there are limited resources, only so much time available to charities for them to, and charity law is complicated enough, and the Charities Act is being, even as we speak, being amended in line with the Law Commission.
Yes, I do find this a little bit surprising, if you're right, because I mean, let's suppose, as you say in this case, that you imposed a religious requirement,
yes,
and that was considered to be lawful, but you also happen to impose an unrelated race bar. You could hardly say that you get a pass on the race bar simply because you got a fail. I mix my metaphors. You understand the point that I made?
I do, although specifically race is specifically dealt with in 193. But the point interestingly can be made. For example, Lord, if say for example the religious requirement were found to be were one related to Hinduism in the United Kingdom. Now, theoretically, one might say, well, that's indirectly discriminatory in grounds of race, because statistically there will be a larger persons of a particular ethnic minority within the United Kingdom who will be members of that and therefore potentially benefit from it. And I'm saying it's those kind of arguments that cannot be opened because you've done the Section 2A proportionality test. And once that's been done, then we do not then have the opening up of further arguments on the basis of further or different grounds. Whereas on Millen and Friends reading, it's entirely open. You're protected sort of in terms of religion, but there still is potential other requirements. Those other considerations would be taken into account by the regulator who would be the Charity Commission at the making the proportionality test at 193 2A. Just on one minor point, Lady Justice Asplin saying that the Charity Commission doesn't decide who is a charity, but I think strictly under section 34 it is to do with removal of charities from the register, but under section 34(1) of the Charities Act 2011, the Commission must remove from the register any institution which it no longer considers to be a charity.
Yes, but it's not the ultimate arbiter of the question. It's an issue about putting people on or taking people off the register. And the register, and we're dancing on the pin, the register is of charitable bodies. But what I was meaning was it is not the ultimate arbiter of what a charity is or is not.
Yeah, indeed, there are. It's a very, very complicated area, but certainly the presumption is that if you're on the register, you are a charity. But the only point that I'm making is that there is a positive duty on the part of the Commission. It must remove from the register any institution which it no longer considers to be a charity.
Which it considers to be, yes.
Yeah, and
so I don't think we disagree.
No, and we're not disagreeing at all. I would very much hesitate, given that I'm certainly not a charity lawyer, and your lady was far more experienced in that area. But the point I take from that, however, is that it's a positive, proactive duty. The Commission must remove from the register any institution which it no longer considers is a charity, and that comes back to my initial what I was saying, is that the fact that the Commission, the Charity Commission in this case, has made a decision has not sought to remove us from the charity over the past 10 years since the decision in January 2011 when we set out our is clearly a positive decision, because if they thought otherwise they'd have a statutory obligation to act rather than just leave it for other regulators eventually to bring to their attention. There is nothing which Ofsted would be bringing to the Charity Commission's attention, because all those matters, it's the same test, it's the same section 193 test. There's been no significant change in the law in 193 apart from the explication of it in Z, and it's exactly the same religion and belief requirements. So the fact that there's a decade between them doesn't justify any change or difference in approach from Ofsted in this case from what the Charity Commission did. My Lord and my Ladies, I think that's all I had in response, unless there are any other points I can assist with.
Thank you very much indeed, Mr. Chairman.
I'm obliged.
Good. Well, inevitably, given the interest and importance of the issues raised on this appeal, we will reserve our judgments. Council will be very familiar, but I'll just repeat that we'll send them out in draft for your assistance in editorial and only editorial correction, and if you would be so good as to draft an order that reflects the terms of our decision, the judgments will be published on the Bailey website in due course, and there'll be no need for any attendance at the hand-down. If there are any matters in the draft order that are not capable of agreement, we'll receive short written submissions, and unless there's some fairly exceptional circumstance, we'll deal with those on the basis of those written submissions. So unless there's anything else that either Council wishes to raise, we thank you. We thank those who have supported you in the preparation of the appeal.